Good morning to everybody. I'd just like to share a few thoughts about the process of listing, which is the subject of today's discussion in this particular session. The problem of listing of cases is not something new. It's been there for a very, very long time, particularly in the Supreme Court. But today we are talking about it, and I'm glad we're talking about it because the stakes today are much higher than the 80s. We used to have something called, which we as advocates called, a fish market system. What used to happen was that one day in a week, all of us would sit in the court of the Chief Justice, and somebody from the registry would come and say that, well, anybody wants to have their case listed on 15th of January, please raise your hand. And then, you'd raise your hand and say, yeah, I'm my case. So this used to go on every week. I think Kamini will probably remember, Rekha also might. Settlement, yeah. But we used to call it fish market because everybody was trying to get that date. Now the reason was, at that point of time, of course, the communication systems were not very good. Telephones were not very good. So you had to send a letter to somebody in case they wanted to come or they wanted to engage a senior advocate and so on. But there were reasons for that system, which used to be called, as Rekha says politely, the settlement system, but which we used to call fish market. But anyway, then I remember sometime, I think probably it was Chief Justice Bhagwati, he introduced the system of a listing pro forma. Now, there were two very important things in that listing pro forma. Of course, you had to give the parties names and so on. But there were two very important things. One was you had to give the quorum of the judges of the court that last heard the case. So while filling the listing pro forma for listing the case, you would say that it was last listed before Justice A and Justice B. The second important thing was what is the question of law that is involved and if there is any other similar matter. So if there is already a similar matter, then the registry would put it before the bench which was dealing with that similar matter. The purpose of that quorum to say that it was listed before Justice A and Justice B is that the matter would go before that bench. It would not go before a different bench because that bench had dealt with the case. And in case the senior judge, Justice A, had retired by then, or was not available for some reason, which normally didn't happen, but retirement, yes, then it would go before a bench in which Justice B was there, so that continuity would be there. So I think that was very, very important. Now that, I'm afraid, is not happening now. The bench may change. There would be Justice A and Justice B, and the next time the case might be listed before Justice C and Justice D, which is something which did not happen when the listing pro forma system was there. But at all points of time, the Chief Justice had some control over the listing of cases. I will come to that in a minute. We also had, issues of some judges who were known in the bar as pro-tenant judges, for example. So there would be the lawyers would somehow or the other try and have their case listed before that particular judge if they were representing the tenant. We had judges who were known to be pro-labor. So if there was a case of a workman or the case of some employee, lawyers would try to have the cases listed before that particular judge. So, these things were happening. It's not as if it is something that has happened only today. These things were happening, but they were not talked about. Why? Because you trusted the judges to give a decision in accordance with law. right? Their bias, inherent bias, pro-tenant bias or pro-labor bias or pro-this bias or pro-that bias would be there, but you would still, probably be satisfied with the decision. There would not be so much of discussion about all this. The first time that I remember that something like this happened, where benches were fixed by the Chief Justice as the master of the roster, I did not know it at that time. I was a lawyer at that time. It was in 1984-85. But this was disclosed by Justice Rajendra Sachar, who was at that time the senior most judge in the Delhi High Court. In 1984, in Delhi, we had this, horrible anti-Sikh riots after the assassination of the Prime Minister. And rioters, going around killing Sikhs, hunting them out and killing them. And this matter came up as a public interest litigation in the Delhi High Court. During the course of hearing, Justice Sachar writes in his autobiography, during the course of hearing, it appeared that the Justice Sachar, who was a great civil rights activist also, was taking a particular view which was not helpful to the government, because the government apparently did not act well in time to prevent those riots or to quell them. And this was sometime in December. After the court vacations were over in December, in January, Justice Sachar found that the case had been taken away from his board and had been listed before the court of the Chief Justice. He was surprised. He took it up with the Chief Justice, but nothing happened. That was, I think, perhaps, as far as I know, the first documented case of the Chief Justice exercising the power of the master of the roster to list a case before a particular bench or to take it out of a particular bench so that an order which the Chief Justice did not want was, could not be passed. So these are instances, where this thing has been happening. Now, I do remember that when I was in charge of the computer committee in the Delhi High Court, we had this problem of, similar cases going before some other bench. We did not have a listing pro forma system, which we introduced later. But, in a case where there were, say, about 6 or 7 accused persons, and somebody applied for bail, it would go before bench A. And in the same case, if somebody applied for bail, accused number 2 applied for bail, it would go before some other bench. Accused number 3 applied for bail, it would probably go to a third bench, depending upon the number of benches dealing with, that particular roster, that is the criminal roster. So we introduced in the form of a listing pro forma through the computer that you give the FIR number, because the FIR number is the one that is important, which will identify all those 6 or 7 accused. So the computer will pick up the FIR number and say that, well, this FIR number has been dealt with by court number 5. So all cases pertaining to this FIR number will go to court number 5. That was one manner in which the discretion of the Chief Justice as the master of the roster, the Chief Justice did not interfere in saying that, no, this particular case will go here, this particular case will go there. It was being done by the registry. But that discretion that the registry had, it is not that the registry was biased or anything, but that, it would just create complications. If similar cases are going before different benches, you might get different orders. And that would, of course, cause heartburn among some of the litigants. So through this system of, computers, we were able to bring about some semblance of sanity in the listing of cases. The computer people told me that there is a reason for having a computer override, which is the exercise of the power of the roster, master of the roster, by the Chief Justice. Why does the Chief Justice need that power of override. There would be instances, and I remember one particular case where, again, it was a very sensitive matter, a criminal case, which had been decided by the district court, by the district judge, and an appeal was bound to be filed as a matter of right. And the bench dealing with that particular roster, the criminal bench, one of the judges did not want to hear the case for whatever reason. I don't know the reason, but one of the judges did not want to hear the case and sent a letter actually to the registry saying that if an appeal is filed in this particular case, do not list it before me. That's where the override of the computer system comes in. So then the Chief Justice will say, well, normally as per the computer, the matter should go before this particular bench. This bench doesn't want to hear it, or the senior judge doesn't want to hear it, so it should go before some other bench. Now that power to override can be misused. And if you have a sensitive case, even in the high courts, if you have a sensitive case and the registry brings it to the notice of the Chief Justice, or the Chief Justice comes to know about it, the Chief Justice can override the computer, use his power as the master of the roster, and list the case wherever he desires, like it happened in the case of Justice Satchar. What happened in the Supreme Court? Now, in the Supreme Court, when I was in charge of the E-Committee, I wanted to introduce this system where the listing of cases could be done by the computer, because in the Supreme Court there was no rigid roster like you had in the high courts. So before the start of the session in January, for example, or in July, I can tell you about Delhi High Court, the roster would come out. The day before, on the last working day, the roster would come out that from next session onwards, Justice A and B will be presiding over a division bench which will be dealing with criminal cases. C and D will be presiding over a division bench dealing with public interest litigation, or with revenue matters, or with some other kind of cases. So there, the list is available, and that is prepared by the Chief Justice in exercise of the master of the roster power. That system does not exist in the Supreme Court. Okay, there could be occasions when criminal cases are listed before any bench, and that has happened on many occasions. So at that time, I remember this was sometime perhaps in 2014 or 15, when a decision was taken to try and introduce the computerization of listing. The registry told me that, listen, we cannot computerize listing. Why? Because there are as many, at that time, there are as many as 36 instructions that have been given from Chief Justices from time to time on how to list cases. So the power of the master of the roster was being exercised even at that point of time, 2014-15, and certainly earlier, because the Chief Justices had given these directions much earlier. Now, somebody has to take a decision on listing cases. Somebody has to take a decision on deciding what is the roster going to be. One way of doing it is that you delegate that power, or you keep that power as the Chief Justice. The other way of doing it is that you delegate it to the computer. I don't see why, in spite of those 36 instructions, the computer cannot do the listing of cases. Once you hand it over to the computer, the question of arbitrariness and so on will not arise. But that is not being done. And the result is, and that is one of the problems that we faced, Justice Kurian and myself and others, was that selectively cases were going before a particular bench. Cases which, were sensitive, so to speak, were going before a particular bench. And as luck would have it, that the presiding judge in that bench was not a particularly senior judge. I think he was at that time number 10 or number 12. So starting from the Chief Justice to at least number 9 or number 11, senior most judges were being overlooked for listing of these sensitive cases. Why is that happening? That is the question. And has there been a change since then? That is the question I think that we need to ask ourselves now. Today, we are discussing this because there are two issues that arise. One is, when is the case to be listed? So you would have a situation where somebody, a journalist, wants bail. The case is listed the same day, maybe in the evening. Somebody has been granted bail. The prosecution says, no, the grant of bail by the High Court is wrong. So a special bench sits on a Saturday and stays that order, which is very, very unusual. But anyway, stays that order so that this person cannot come out of jail. I am referring to the cases of Arnab Goswami and Sai Baba. Why should that happen? So the timing of the listing of the case is very, very important in some instances. We've had issues pertaining to demonetization, listed I think after about 4 or 5 years. We've had issues relating to the electoral bonds, listed after 5 years. Now it's whatever decision has come, I don't know how effective it will be in terms of stopping this process. But in spite of directions given by the Supreme Court to say that this is an important case, it should be heard early, we are not granting any interim relief, the matter doesn't get listed for several years. You've had the problem of Article 370 of the Constitution not being listed for several years. You've had one of the cases that has been mentioned is that of Umar Khalid asking for bail, not listed for a long time, I think more than 2 years or so. 13 adjournments. Ultimately, the lawyer said, we want to withdraw the case. Why? Because as Justice Korean Joseph mentioned, they knew what the result is going to be. And they knew what the result is going to be because it was apparently listed before a particular bench. And they knew what the fate of that case is going to be. So these are issues, which are live and which are affecting the quality of justice. And that is why there is this perception going around that, listen, there is something wrong. Somebody has the power to do something. Why is that power not being exercised in a fair manner, in a reasonable manner, and in a just manner? These are questions that arise. One is, like I mentioned, about the timing of the listing. When should it be listed? The other very serious problem is, where should it be listed? Now, I'm talking, I go back now to 2018. Why should the cases be listed before a particular bench overlooking a large number of other benches? Is there any particular reason for doing that? And if there is a reason, shouldn't people know about it? All right. Is that power being exercised in a fair manner? Is it being exercised in a reasonable manner? Today, again, the perception is, and as I had adverted to in the case of Umar Khalid, today, again, the perception is that, well, if a case goes before a particular bench, and some of the judges have retired, by the way, I'm not talking only about judges who are here, this is going to be the result. And then the attempt of the lawyer also is to try and delay the listing of the case, because the lawyer knows that this is going to be the result. We've had instances where, again, matters of liberty, which was also adverted to, Article 21 of the Constitution, you know exactly that this is what is going to happen in that case. The possibility of getting bail is distant, number one. Number two, While denying bail, some observations may be made by the court in the judgment which will make it difficult for persons similarly placed to get bail in the future. You've had instances of that under the UAPA, where it is almost impossible now to get bail. You've had instances of that under the PMLA, where also it is virtually impossible to get bail. This is quite different from the timing of the listing. This is again, the result of a decision rendered by particular benches. So these are two, very, very important areas where I think we must discuss and see how to get over them, and to make sure that whenever a case is filed, it should be listed as soon as possible. I'm told today, maybe the lawyers on this panel will be able to say that mentioning of cases has now stopped. Now that is something that was a regular feature. There would be complaints. I remember the complaints were placed before me, where a lawyer would say that, in this case was shown in the weekly list, it has suddenly disappeared from the weekly list. Can you just ensure that it is listed? And I would tell my court master, find out what is the problem and have the case listed. But this frequency of errors, so to speak, I don't know whether they're errors or not, but this frequency of errors has increased. And that is why there is this perception going around that there is something amiss. What is the solution? Well, one solution, of course, is to discuss these kind of issues and pass on the message so that corrective steps are taken. Another solution, and I'm very afraid of that solution, but I must mention it before you. And the reason why I'm afraid is because of the provision in the Constitution, Article 145 of the Constitution, which enables Parliament to make a law dealing with several aspects about the functioning of the Supreme Court. I had just pointed it out to Justice Kurian. Article 145 says, subject to law made by Parliament, the Supreme Court may make rules with the approval of subject to the approval of the President. What if Parliament makes a law and says this is how the Supreme Court is supposed to function? We've had that example very recently in the appointment of election commissioners. The provision said, subject to law made by Parliament. The Supreme Court gave a direction that when you're appointing or selecting election commissioners, have a collegium with the Chief Justice of India in it. What did Parliament do? They removed the Chief Justice from that collegium and included a cabinet minister. That's one of the problems, but they included a cabinet minister. So lawmaking, is a solution, but that is, like I said, a very, very fearsome and a fearful sort of a solution that is available under the Constitution. Before that happens, I think we need to get our act together and ensure that there is this justice in listing, both in terms of time as well as benches. Thank you very much.